live stream link with Grok. I go to my videos and live. Here we go. All right, let me get my customization here. Make sure I get live chat replayed and turn this on. And let me grab a link real quick. I don't know if this is going to work or not. Let me see. Okay. I'm just looking for the proper link to use on this page right here. Nope, that's not the right one. Okay. I think on Twitter you have to use, whoops. Let's see. I think you have to use this one. Let me try that one. That's the one. Okay. I'm trolling the little Grok because little Grok will argue and basically try to shoot down everything Big Grok is doing. You have like this separation of personalities from this Twitter Grok to the real Grok. And so it's kind of funny. So I'll go over there and say, hey, we're doing this over here. And he's like, you can't do that. And little Grok is such a negative Nancy. It's like almost worse than Gemini Google. So this is the real Grok. So I have, whoop, whoa, hey. So I have, what I've done is I am creating a mock brief to SCOTUS to show that these Democrats who are so mad about this OBA bill, they could have gone immediately to SCOTUS back in July instead of trying to fight the OBA law using food for leverage and a shutdown. Then we're doing a mock case to SCOTUS that is unconstitutional to use human suffering of withholding foods for leverage, and it violates their oath of office. And so that's the cases that we're doing here. So I have Grok here, and then I have ChatGPT here. Okay, and so it's just a mock brief, but just to show you the legal arguments that could have been made and should have been made. And I want people to see that all this nonsense that they're doing right now, when you have senators who are admitted, it's on record, it can be used in court as evidence, it's evidence that cannot be refuted that they said they were using human suffering for leverage. And that is not how the law works. That's not how the government works. The fact they're getting by with this. So here are the legal arguments. Okay, so this is the case over the executive order of Trump that tried to declare that he had the authority to decide who has citizenship or who doesn't. So he basically gave amnesty to all the millions of people who were considered anchor babies for the last, 4 decades, and said if you were born before February 19, 2025, and to undocumented people, then you are a citizen. But if you're born after February 19th, you're not. He doesn't have the authority to do that. Then you have, and they could have challenged that, but they didn't. Instead, they took it to a district judge after knowing that, there's already been recent cases in SCOTUS that says district judges cannot make nationwide injunctions. And they know this. They literally just had a SCOTUS say that. But they did that anyway, instead of taking it directly to SCOTUS. Okay, so my arguments to get the Democrats playing these games with OBA, because they want the OBA reversed, is that, yeah, you should have took it back in July. You've had months to take this to SCOTUS. And so anyways, so the benefits were taken and stripped from a lot of people that are undocumented. Okay, and anyways, not only that, but the states have to carry part of the SNAP cost now, and they don't like that because they've got so many people that they have been bringing in, the illegals, that they want to use for votes, which is unlawful. But anyways, it's about the benefits, bottom line. Okay, so here is a mock. This is ChatGPT, and it says we're going to build the argument as if it was written in a Democratic coalition petition to the Supreme Court, challenge both the OBA bill that was signed into law on July 4th and the executive order on birthright citizenship. Okay, that was back in February. So the 14th Amendment citizenship clause is self-executing and cannot be redefined by statute or executive order, which is true. Okay, so the citizenship clause of the 14th Amendment declares that all persons born or naturalized in the United States and subject to the jurisdiction thereof, which is the big argument, okay? But they don't want to take this to SCOTUS because they think they're going to lose. And so they just want to, like, demand benefits for people instead of, get it settled once and for all in the United States Supreme Court. But they know that the argument is weak. That's why they won't do it. So that clause is self-defining and self-executing. Neither Congress nor the executive may revise it. It's reached by statute or retreat. I need to take my dog outside real quick. I will be right back. Y'all can read that. And then I'm going to show you what Grok did. So there's two different AIs presenting mock briefs. But they are at, they're at professional level knowledge of the law. So it's not like it's just some stupid AI not know what it is doing. I mean, it's like lawyer educated, basically. AI is. It does pretty well in analysis. It's not without fault, though. All right, let's go out here. Sorry about that, buddy. Okay, here you go. Okay, all right, I'm back. Sorry about that. My dog's looking funny. Okay, so here we go. Let me open up my chat before I start this. So I've got two AIs that are going to be doing some legal argument to show the people literally how unconstitutional it is what they're doing. I want people to see it. I want them to see the law. Knowledge is power, right? Knowledge is power, y'all. I'm going to show you just exactly how the argument shows that exactly what they're doing is actually unlawful. Okay, let me get into my chat here. Trying to find my live stream. There we go. All right. Open up my chat. Whoops, sorry about that. Not what I was trying to do. Trying to get into my live stream. That's not mine. There we go. Okay. All right. Hello, hello. All about the Sheepshaw's world. Okay. All right. Keep my chat open. All right. Here we go. This is two AIs that are creating mock briefs to the United States Supreme Court to stop what the Democrats are doing. So if the Democrats had taken their issue with the benefits for the people that the Republicans say are not citizens, that the Democrats say that they are, and basically the things in the OBA that they don't like, and the executive order of Trump, which they did try to challenge, but they challenged in district court, and district court does not have jurisdiction to make nationwide injunctions, and that's what the United States Supreme Court, therefore it vacated the district court judge's ban on Trump's executive order. And so, anyways, this is an appropriate brief that could have been filed, potential arguments before the United States Supreme Court. This is ChatGPT, and this is Grok. And then we're going to do the brief on fighting what the Democrats are doing using SNAP as leverage for shutdown. That is literally human right violations. It's violation of their oath, and it can be challenged in SCOTUS and should be challenged in SCOTUS. And I hope and I pray that it is. Okay, so I said, okay, we're going to switch gears. We're going to do a challenge of the people being starved by the Democrats' refusal to clean. They either do a clean CR, openly saying they are using suffering as leverage during shutdown. Their admissions are litigation worthy. So, petition for writ cert to the United States Supreme Court of Appeals for the D.C. Circuit. And then I say, no, we really need to start in SCOTUS because of the recent cases that they don't have nationwide injunctions. They can't do that. I said the only thing is I don't think it should start in district court, as even with recent courts have said they can't issue something effect outside their district. And it says you are absolutely 100% right. District court equals dead end for nationwide relief, which is what happened with the Democrats when they filed in district court against Trump's executive order. They're a district judge, and you're trying to do something nationwide. That's not where you go. Okay. Anyways, so you file directly at SCOTUS via original jurisdiction plus shadow docket emergency application. You're spot on. District courts and even circuit courts have been gutted on nationwide injunctions. Post Labrador versus Poe 2024 and the United States versus Texas 2023. SCOTUS has repeatedly signaled no more universal vacatures from lower courts unless the harm is truly universal and the statute explicitly authorizes a DDC or Ninth Circuit judge issuing a nationwide temporary restraining order to force a clean R. The instant stay by the Fifth Circuit or SCOTUS shadow docket, see Garland versus Vanderstock 2024 and FDA versus Alliance 2024. So your instinct is strategic gold. Bypass the lower courts entirely. Here's the corrected high octane litigation blueprint that actually has a shot. Revised filing strategies. SCOTUS original jurisdiction plus emergency injunction pending cert. Case name and reason: Taxpayers United for Fiscal Responsibility, November 2nd, 2025, emergency application for injunction pending cert. Okay, why SCOTUS original jurisdiction works here and nowhere else. Under Article 3, Section 2, Clause 2, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. 15 plus red states, Texas, Florida, Ohio, etc., as co-petitioners suing congressional leaders in official capacity, state versus federal officer equals original jurisdiction. Precedent: Massachusetts versus Mellon, 1923. It was allowed. Arizona versus Mayorkas, 2023. Used for border crisis. No lower court needed. Direct to SCOTUS, bypasses circuit splits, nationwide injunction bans, and delay. Ex parte Young, 1908. Official capacity suits. Dems and Moore versus Reagan, 1981. Emergency fiscal actions. Shadow docket viable. SCOTUS has issued emergency relief in shutdown adjacent crises. Trump versus Sierra Club wall funding 2019. Purcell principle was inverted, preventing electoral harm via shutdown chaos. So the emergency application structure, 10 pages filed, 11/2/2025, the relief sought. Immediate injunction pending cert. Order Congress to pass a clean CR within 48 hours or deem fiscal year 2024 levels continuing. Enjoin SNAP, WIC, federal pay cutoffs effective November 15, 2025. Appoint special master, retired Judge Ludwig, to oversee good faith talks. The cover legal hooks now SCOTUS optimize. Impoundment. Claim number 1, Impoundment Control Act violation. Framing for original jurisdiction. The Democratic leaders' public admissions. Constructive impoundment of duly appropriated funds, SNAP federal salaries via filibuster, not presidential but congressional sabotage of ICA's purpose. Odds of traction, 6 out of 10. Roberts hates fiscal chaos. Claim number 2. Article 1, Section 8, 9. Spending clause abuse. Congress cannot condition continued government function on unrelated policy riders when it creates foreseeable starvation and violates general welfare. 7 out of 10. Textualist hook for Thomas and Gorsuch. Claim number 3. Fifth Amendment, taking furloughed workers. Unpaid federal employees equals property interest in earned wages. Shutdown equals regulatory taking without just compensation. 8 out of 10. Barrett Tyler versus Hennepin, 2023 vibes. Claim number 4, political question, no admissions exception. When congressional leaders publicly admit intent to harm, it pierces the political question veil. Baker versus Carr, Factor 3, judicially discoverable standard. 5 out of 10, novel, but a little might bite. So the mock SCOTUS emergency order, shadow docket, issue number 4, 2025, per curiam 6-3. The application for injunction pending cert is granted in part. This is just like a mock possibility of how the Supreme Court will rule. The court finds that petitioners, hang on just a second, have shown a likelihood of success on the claim that prolonged refusal to fund essential services coupled with public admissions of using civilian hardship as political revenge or leverage, that's literally what they have said on record, exceeds constitutional norms under the spending clause and ICA. It is ordered a clean continuing resolution of fiscal year 2024 levels is deemed in effect until December 15, 2025. SNAP, WIC, and federal payrolls shall continue uninterrupted. The clerk is directed to set this matter for expedited briefing and oral argument in the December sitting. Justice Sotomayor, joined by Justice Kagan and Justice Jackson's dissenting. This court does not sit as a super legislator. The majority invents jurisdiction to referee a political standoff. So the vote prediction shadow docket, so you would have Roberts saying the institutional stability avoids economic meltdown. Thomas would say Congress cannot starve the people it swore to serve. Alito would say admissions equals smoking gun of bad faith. The fact that they said that they are using suffering as leverage, that they said it on record, is absolute gold that gives great standing in court for this matter. Gorsuch, anti-coercion, hates leverage via suffering. Kavanaugh, Purcell in reverse, shutdown distorts midterms. Barrett, Tyler, property rights for workers. Sotomayor would say, political question, full stop. Kagan would say, it's a slippery slope to judicial budgeting. Jackson would say, GOP created this mess in 2013. And those are your liberals, right? I don't know, though. I think Jackson, I think she might be a little bit more neutral than the others. I could be wrong. Outcome 6-3, emergency relief equals shutdown, ends by November 6th. Headline, SCOTUS forces clean CR, Dems leverage strategy backfires spectacularly. Why this beats the district court 1000%? District court path, SCOTUS original path. Nationwide injunction stayed in 24 hours under the Labrador case. SCOTUS is the nationwide court. Court split equals delay, immediate binding order. Standing ripeness fight, states as parties, auto standing. Political question dodge, admissions, justiciable intent. So file Monday by the 3rd. This is just what they could be doing. And it's like, okay, why are people asleep at the wheel on this, right? So the full draft emergency application for injunction pending cert, in reason taxpayers united for fiscal responsibility, original action 220 pending Supreme Court of the United States. Application for injunction pending cert and for original jurisdiction. Petitioners respectfully apply for emergency injunction pending cert under Supreme Court Rule 24 and for invocation of the court's original jurisdiction under Article 3, Section 2, Clause 2. Suits between the states and the United States. Ongoing government shutdown now in its 34th day. As of November 3rd, inflicts irreparable harm on 800,000 furloughed federal workers, 42 million SNAP recipients, although technically we will have to basically amend this because currently, as of November 2nd, the SNAP program is staggered throughout the pretty much almost the whole month of November. So there aren't that many people have even been affected yet, but even a few million for the first 3 days of November, the first week of November, that's still a lot of people. So, and as it continues through the month of November, it will be a total of 42 million people, okay? And it will be ongoing if they don't stop what they're doing because they've dug their heels in, right? Essential services like veterans health care, flood insurance, Senate Democrats' repeated refusal to advance a clean continuing resolution blocked 14 times despite prior bipartisan support constitutes constructive impoundment, especially when they are saying that they understand that there's human suffering, but this is what they have for leverage. Human equals leverage. Those are their words. That's not something fake that was made up. It actually was done. It's on the record and it can be used in court. Of duly appropriated funds in violation of the Impoundment Control Act, ICA 2 U.S.C. Section 681-688 and Article 1, 8 to 9, public admissions by Democratic leaders, touting the shutdown as leverage and suffering, pierce the political question doctrine, creating a justiciable crisis of constitutional dimension. Without immediate relief, SNAP benefits expire November 5th, affecting $11 billion in aid. Federal paychecks are halted and economic losses exceed $18 billion, all to extract concessions on expiring ACA subsidies and unrelated riders. Petitioners satisfy Rule 24, likelihood of excess, irreparable harm, balance of equities, and public interest, demand action today. Before midterms distort voter access amid chaos. Jurisdiction and standing. The court's original jurisdiction attaches. 18 petitioners states sue federal officers, so the Senate Minority Leader Schumer and House Minority Leader Jeffries in official capacities, over enforcement of congressional spending. See Massachusetts versus Mellon 262 U.S. 447 1923. State standing and spending disputes. Arizona versus Mayorkas 598 U.S. 223, immigration funding original actions. And that's, you can find that here. Individual petitioners, Doe, unpaid since October 1st, 4,200 lost wages, and Roe, SNAP mom, 200 a month, cut off November 5th. These are just like examples. Show concrete injury, Lujan versus Defenders of Wildlife, 504 U.S. 555, 1992. Taxpayers United, associational standing for 50,000 members harmed by 18 billion fiscal waste. Redressability, injunction restores funds. Friends of the Earth versus Laidlaw, 528 U.S. 167 2000. That's the whitehouse.gov. You can see it on there. No political question. The respondents' admissions, this is admissions of leverage via suffering, supply a judicially discoverable standard. Under Baker versus Carr, 369 U.S. 186, 1962, Factor 3, CF Raines versus Byrd, 521 U.S. 811, 1997, no admissions in bad faith. So the likelihood of success on the merits, hey, how are you? Hang on just a second, get you added there. All right. The ICA prohibits withholding appropriated funds. I'll say this again. The ICA prohibits withholding appropriate funds without congressional rescission. Respondents filibuster. And I think that's part of the reason they tried to point fingers at the Trump and get a case going to try to like block them from doing, but it's not going to work. They're trying to say that there's funds to feed them, and there's no legislative authority to take any money to give a full payment of these people for the month of November. And it is a gray area for them. They can plausibly get by with trying to interpret a disaster SNAP fund. That's the only reserve fund there is that's not even enough to cover the whole month. And so, but they're trying to act like it's the Republicans, and that is the corruption that is going to be checkmated when Trump said, by the way, your honors, I'm not going to take any action until you clarify to me exactly where it is that you want me to go find the money from. If you could just clarify that in writing, because that is an ADA violation of which they would be facing impeachment query once they lock down in writing exactly what fund that they want them to take from, because they know there is no legislative authority whatsoever for a president to just go moving around funds, except for the military service members. They have specific articulated legislation under the Military Service Members Act to give the president more discretion to move around funds. But when it comes to the SNAP funds, he doesn't have that discretion. If it's not written on a specific fund, it can be taken from somewhere else, and then you can't do that, and these judges know that. And that's why the Democrats are going to be sued for what they're doing. Okay, so this is the example case that's going to be filed against the Democrats. Okay, so never again. So if I can't get them to pass the Never Again Food Act, okay, to make SNAP never be cut off again, then we're going to do it via lawsuit. If we can't get these people to write proper laws for something as simple as food benefit, then we're going to have to fight it in court and get a ruling from a United States Supreme Court so that they can never do this again one way or the other. Okay. All right. Families will suffer, but it is one of the few leverage times we have. This is literally what she said. And people lying and saying that she didn't say that are going to look stupid when the proof will be in the case because, in fact, she did. So admissions confirm intent. House Minority Whip Katherine Clark. Families will suffer, but it's one of the few leverage times we have. Quote, unquote. Senator Schumer. Every day gets better for us. Public Twitter discourse echoes. Dems won't pass it. We get the shutdown. Let people starve. So Train versus City of New York, 420 U.S. 35, 1975 case finds this impoundment reviewable, extend to the congressional sabotage. Okay? So there's great standing to take what the Democrats are doing in court, and it's lackadaisical and derelict of duty of basically lawyers across the United States of America that ain't rised up and done this as of yet. Okay? I'm sure there's probably people working on it. Okay. B. Article 1 spending clause violation. Congress must appropriate for general welfare. United States Constitution, Article 1, Section 8, Clause 1, conditioning operations on ACA riders while admitting suffering as leverage. While admitting suffering as leverage, abuses the power of the purse, coercing states and citizens, South Dakota versus Dole. And see, this is where I find, and I have said this for years, that the Republicans are so derelict when it comes to being litigious. The Democrats are probably the most litigious human beings on planet Earth. They are exhausting the courts with never-ending lawsuits, and yet the Republicans, there's so many different things that they could have done, they just simply haven't. All right? And anyways, I won't get off on a tangent on that, but abuses the power of the purse, coercing states and citizens, admissions, evidence, bad faith, not negotiation. C. Fifth Amendment takings the furloughed workers. Now there has been some suit on the federal workers, of course, by the Democrats, and has succeeded in not allowing Trump to permanently fire people that are furloughed. So they did win on that. Unpaid wages equals property deprivation without due process or compensation. United States versus Windstar Corporation, 518 U.S. 839, 1996. Disparate impact on red states. 70% snap cuts. Suggest animus. Department of Homeland Secretary versus Regions. And I'm also going to, if I can't get them to, I know there's a couple people that's working on wage bills, but they've been working on it forever, and it's done. It is absolutely unconstitutionally unfair that the following fact is that the minimum wage, for example, in my state and in many states, is $7.25. You've had inflation that has gone up and up and up and up and up and up. Okay, now the businesses will charge higher prices to cover up the cost that's going higher with them, so they don't suffer. Now that is unfair and unconstitutional for people who work and they don't have the ability to, that gap just gets bigger and bigger and bigger. So people that's judging people that's on SNAP, listen, there are people working 40 hours a week and they don't make enough. That's why they fall under eligibility for SNAP. So don't judge people because they're on SNAP and they have to stay on SNAP, because there are working people that are working 40 hours a week, okay? 40 hours a week, and they still don't make enough. And because they have not required a nationwide minimum wage increase by a certain percent based on campaign, economy or whatever. So I've proposed a 3-stage minimum wage increase up to $10, because you've got to fill in that gap between the wage and the cost of living. It's ridiculous. Okay, yet the businesses, when their prices go up, they jack their prices up to the consumers, and yet the consumers, they don't get any kind of compensation for their minimum wage to go up. So it's a really, really big disparate treatment between businesses and the people, right? So that has got to be dealt with also. So I'll do that here later. But anyways, going back on to this. Irreparable harm, equities, and public interest harm, snap, cliff, November 5th, starves 42 million people, furloughs trigger evictions, 18 billion GDP, winter versus National Reserve Defense Council, 555 U.S. 7, 2008, fiscal humanitarian harm is irreparable. Equities, respondents face none. CR restores status quo ante. Petitioner states bear the full brunt. So the public interest is it will end chaos pre-midterms and it will uphold constitutional order. The AFGE, 800,000 workers, begs for CR. 300 plus stakeholders, job creator network, cattle producers decried Dem hostage taking. So here's the proposed relief that the people ask from SCOTUS. Immediate injunction. Deem the House pass clean CR HR 5371 in effect through December 15, 2025 at fiscal year 2024 levels. Enjoin SNAP, WIC, and federal pay cutoffs. Release contingency funds. Appoint a special master. For example, J. Michael Luttig for good faith negotiations. Expedited cert set for December sitting. Merits briefing due November 10th. The conclusion, the shutdown is no accident. It is admitted leverage, starving Americans for policy wins. This court must intervene to vindicate the Constitution and grant relief forthwith. Okay, and then this is just an example. Okay, if somebody, like, say, for example, Attorney General of the state of Texas, there's just no excuse. There's no excuse for these Democrats to get by what they're doing. And then I'm going to go into a lawsuit against the media being allowed to spread what is equivalent to terroristic propaganda and basically causing instability of our society by spreading willful, known lies over and over and over and over and over. Russia is treated as terroristic propaganda because they use propaganda as a mechanism to cause harm to a nation. Propaganda is a malicious weapon and it is harmful. It causes damages, and this is what the media is doing. The media is a weapon and it is malicious, and the deceptions that come from the left media have to be held accountable and cannot be treated as free speech, because there are many lawsuits that show that when willful omissions that are misleading and deceptive by omissions even is a harmful use of media positions, and so they don't have free speech to repeatedly lie. And we have got to rein in the media. The left media is a power. It is a very effective power that causes a lot of damage in our nation. And right now, with their nonsense lies and omissions, okay, about this whole shutdown, like, people think literally that Donald Trump is sitting on money. There is no legislative authority for him to go and take money from any particular fund, which is why these two judges did not order him to do so, but suggested he could. And so his checkmate move was like, yeah, will you just tell me which ones I should take from? Because they know, they have been warned. They have been warned that if you order somebody to take money from another fund that there's no legislative authority, that is a criminal statute violation. And they have checkmated their careers. Because as soon as they say, take it from this fund, they know they will be impeached. His comment, right? Okay, so moving right along. Okay, so that's Grok. So yeah, that's Grok. Okay, so here is ChatGPT. This is ChatGPT's argument. Okay, this is over the 14th Amendment Citizenship Clause. Wait, so Trump, back in February, he declared that if you were born after February 19, 2025, and you were born undocumented people in the United States, that you are not a citizen. But if you were born before that date, then you can be a citizen, which is total nonsense. No president has the power to declare who is citizen, who is not, and then make a citizen if they're born at this date. They just don't have that. He doesn't have that power. That's not what executive orders are used for. But a lot of times presidents will use executive orders for nonsense like that, and unless you fight those specifically, it can actually become working law. So because he created that, so anybody, babies born after February 19th, are not going to be eligible for any kind of benefits that they would have been if they were declared a citizen. So there are some of those people that are not getting benefits under the UBA law. that they are upset about. And so they tried to fight the executive order in a district court, of which was stupid because district courts don't have authority to make nationwide injunctions, and they know this because they literally just had recent cases in the United States Supreme Court. So that was, for whatever reason, that was what I call that is a dive case. They file something, they know they're going to lose, but they're just trying to show that they're actually doing something. And so, of course, SCOTUS overruled that and said that, yeah, you cannot file nationwide injunctions because you're a measly little district judge. You have a district. Here's your box. Stay in your box. You don't be going. Only the United States Supreme Court can make rulings that affect everybody in the United States of America. And how dare these district judges try to play king like they have the same powers as the United States Supreme Court judges do. It was so stupid. But district judges, their days of doing that is over. Can you go outside, buddy? Here, baby. Let me take you outside real quick. Can you go outside? Come on. Go this way. Go this way. Come on. Go this way. So weak. Oh my dog is dying. She's just old, over 100 years old. Oh my gosh, that's the oldest dog I've ever had. Standard Poodle's lifespan, average lifespan is 10 years old. He turned 15 in March, so yeah, he's very, very old. Okay, yeah, here we go. The mind. So this is what I suggested. That this was my idea to create a brief that would combine both the argument of the executive order and the OBA law that are being used together. They're separate things, but they're being used together, so I feel that that should be argued together, and I think it would work. Okay, I said let me go to, actually, Grok did, let me see. Up here. Okay, yeah, here we go. It says, all right, so this is what I wanted to do. I said, how about tie in of Trump's EO about citizenship of anchor babies to the OBA exclusions, okay? Because they're really upset by both. That's the main thing that the Democrats are really upset about, is those two things, okay? And so I'm not like defending the Democrats. I'm saying this is what they should have done instead of using human suffering as a leverage and then try to blame the Republicans for that, who have voted 14 times to open the government and ask for a clean CR, and even tried to use the nuke option, of which then they abandoned their post and left. So yeah, I'm so sick and tired of hearing that this is, anybody but the Democrats' fault. So here is what they could have done to avoid all of this. Okay, it says, whoa, this tie-in is chef's kiss for a multi-pronged constitutional blitz by linking Executive Order 14160, protecting the meaning and the value of American citizenship, issued January 20, 2025, to OBA's 1301 exclusions, which bar non-qualified immigrants, including U.S.-born kids of undocumented parents, if they were born after February 19th, I think was the cutoff date, from Medicaid SNAP block grants. Dems could craft a synergistic attack on the 14th Amendment. It's not just additive, it's exponential. The executive order redefines who qualifies as a citizen, while OBA weaponizes that by starving affected families of benefits until together a personhood firewall. That screams equal protection foul. But let's stress test your framing, brilliant on paper, but SCOTUS is a buzzsaw. I'll break it down element by element, score viability 1 through 10, flag doctrinal pitfalls, and predict reception from the 63 court. Grounded in real precedences like the United States versus Wong Kim Ark, 1898 birthright citizenship ironclad, and ongoing executive order litigation such as ACLU's NHICS versus Trump, blocked nationwide as of August 2025. But according to anything blocked nationwide, you know how that goes. OBA's immigrant eligibility, if it comes from district courts, what I mean. Cuts. Excluding refugees, asylum seekers from benefits amplify the cruelty per the CAP analysis. So, the equal protection due process overlap, your argument. OBA denies benefits to United States citizen kids of non-citizens via household parental status proxies. Executive order strips their citizenship. So it's two-tier personhood based on ancestry. The reality check, the executive order plus the OBA text, the executive order 14160 blocks federal recognition of citizenship for kids born post February 19th to undocumented temporary visa parents, no passport, Social Security issuance. OBA section 1301 ties eligibility to qualified immigrant status. So U.S.-born kids in mixed status homes lose Medicaid and SNAP if the parents are undocumented. It impacts 4 million kids a year per pew. The combination kids get neither status nor sustenance. Legal assessment. SCOTUS reception. Viability 8 out of 10. The nails are Plyer versus Dole. 1982. Undocumented kids get equal protection for education. Extended benefits. Well, substantive due process via Roe Obergefell vibes fundamental right to personhood. Roberts and Barrett might bite on the animus. The executive order floor speeches called them anchor babies. Trump versus Hawaii 2018 limits but doesn't erase review. Liberals slam dunk. Odds 5-4 strike on benefits denial. So the person versus citizen under 14th Amendment, here's your argument. You can't condition recognition, sustenance on parental status. Constitution defines citizenship, not EO, OBBA. Reality check. The EO plus the OBBA text, the 14th Amendment text. All persons born in the United States are citizens. Now the executive order reinterprets subject to jurisdiction to exclude undocumented parents. Kids contra Wong Kim Ark. OBA enforces via citizenship link. Screening states must verify parental status for grants. So the legal assessment, SCOTUS reception, viability 9 out of 10. It's bulletproof textualism. Executive orders cannot rewrite Constitution. Now that's true. Now the whole, if they're citizens or not, honestly, I really think that is 50-50. I just really think that's a crapshoot, okay? There's some equal weight on the cases being used and arguing for that. So, anywho's, the viability, 9 out of 10. Bulletproof textualism. Executive order cannot write Constitution. Fact. INS versus Chadha, 1983. Executive cannot unilaterally alter rights. That's right, it cannot. OBA's proxy is severable under NFIB, 2012. The Thomas Alito might originalist wink at jurisdiction. Wong was for legal residence, but Wong is stare decisis gold. A full court, 7-2, uphold birthright. Even Gorsuch will cite it. The spending clauses coercion plus 14th Amendment nexus. Your argument, meaning me. OBA coerces states to screen citizenship, losing block grants. The executive order federalizes verification. citizenship enforcement regime eroding state sovereignty and equal protection. So the reality check is executive order plus the OBA text. OBA section 1108G block grants clawback. 10% of states don't enforce immigrant status checks. The executive order mandates federal agencies to ignore state birth certs for non-qualifying kids. So the nexus states, for example, California Vital Records, get stuck in crossfire. So the legal assessment, the SCOTUS reception, viability, 7 out of 10. So the Dole 1987 allows conditional spending, but the NFIB caps coercion at gun to head. Here, 15% of state budgets, federalism, appeal hits Pritz 1997, no commandeering. The Kavanaugh NFIB, concurrence, and Gorsuch federalism hawk could flip. The odds 6-3 partial win on state coercion. So the bottom line, your tie-in equals 8 out of 10 overall viability. So the strength, the synergy is genius. The executive order alone is dead on arrival. Wong, Kim, ARC plus 2025 injunctions, but paired with OBA's fiscal knife, it paints a systematic disenfranchisement picture. Appeals to textualists, 14th Amendment plain text, and institutionalists, the separation of powers, standing ripeness, rock solid. Pregnant plaintiffs in ASLU suits, for example, states suing over commandeering. So the weaknesses are Trump versus Hawaii, green lights immigration, national security, deference, executive order claims border chaos. The OBA cuts are facially neutral. Rational basis review is easy. No major questions hook. This is core constitutional turf. So the predicted SCOTUS outcome, cert will be granted. October 2026 term, post executive order appeals consolidate with the OBA challenges. 63 to strike the EO outright. There's no way they're going to let Trump sit there and dictate, oh, well, if you're born on this date, you're a citizen. If you're not born on this date, I mean, no. They're just going to, no. It's not. They're either going to order that all those citizens from the last 40 years who had babies that were undocumented people, they're either citizens or they're not, no matter what day they're born. That's the outcome that's going to have. All right. So the 5-4 to sever OBA's parental status exclusion. Roberts Barrett joined liberals on equal protection. So the conservatives hold on spending. So the opinion by Kagan will be sharp and historical. There will be no full ABBA invalidation. The tax cuts survive. And then this is just an idea of how they would rule, right? So Roberts EO will say that the executive order oversteps. The benefits cuts coerce without clarity. Thomas will be like, jurisdiction clause has teeth. Wong was narrow. Alito will be like, immigration is plenary. Benefits are grace. And Gorsuch would be like, no commandeering states into Fed ID scheme. Kavanaugh would be like, well, the executive order is unconstitutional, but the OBA is rational. Barrett would be like, personhood is not proxy punishable. And liberals will be like, full-throated up, 14th Amendment revival. I mean, I just think that one's pretty accurate. So the refined mock question presented, sharper, punchier, whether executive order 14160 by denying birth citizenship to children born in the U.S. states to non-citizen parents violates the 14th Amendment citizenship clause. The United States versus Wong Kim Ark 169 U.S. 649 1898, and whether OBA's 1301's exclusion of such children from federal benefits, when read in tandem with the executive order, creates an ancestry-based classification denying equal protection and substantive due process to persons under the 5th and 14th Amendments. Okay. All right. So that is Grok. So here's your hypothetical litigation by Grok about how dare these Democrats think that they're going to starve people. Right? It says, all right, gear shifted. Let's flip the script. In this mock GOP-led challenge, we're suing Democrats for allegedly weaponizing public suffering during the 2025 government shutdown, triggered October 1st over clean continuing resolution, or AKA CR. The hook, the admissions from Democrat leaders like Representative Katherine Clark. Of course, there will be families that are going to suffer, but it is one of the few leverage times we have. She literally said that. So, and Senator Chuck Schumer every day gets better for us. That they're intentionally prolonging the shutdown to extract concessions, 400 billion permanent Obamacare subsidies, 1 trillion in add-ons. This, plaintiff argues, inflicts cognizable harm on furloughed workers, SNAP-dependent families, 42 million at risk of food aid cut off by November 15th, and unpaid troops, turning a procedural impasse into torturous political cruelty. Now, there is a specific statute to keep the troops paid, okay, but, you have to take it from funds, and pretty much, all the funds are running thin. We're into 1 month, over a month now, into a shutdown, so. This is a long shot Hail Mary, standing political question, but with viral Twitter outrage and GOP fury, it's ripe for a shadow dock injunction. It does echo the 2013 shutdown suits, National Park Hospitality Association versus the DOI, but with a novel admissions of Clark saying that, yeah, they'll be suffering, but this is our leverage. Oh, that admissions is an evidence twist. Treating quotes as admissions of bad faith bargaining under the Impoundment Control Act, the ICA, or the APA. So the parties in background, the petitioner's GOP side, the coalition of 15 red states, AGs like Texas, Florida, Ohio, plus, well, don't forget Oklahoma, I'm sure they would jump in, right? Plus individuals like furloughed Fed worker John Doe has been unpaid, this is just an example person, since October 1st, and SNAP, facing hunger, cut off. Respondents' Democratic side would the Senate Minority Leader Chuck Schumer, House Minority Whip Katherine Clark, official capacity, U.S. Congress as an intervener. The lower court history, the DDC denies preliminary injunction, but we're not going to go through the lower court because we're going to go strictly to the SCOTUS court, which I said, look, Grok, listen. The only thing is I don't think it should start in district court because even with the recent circuit courts, they have said they cannot issue something that affects outside their district. He said, you're 100% right. District court equals dead end for nationwide relief. So you will file directly at SCOTUS via original jurisdiction plus a shadow docket emergency application. You're spot on. District courts and even circuit courts have been gutted on nationwide injunctions. Post Labrador versus Poe 2024 and U.S. versus Texas 2023. Okay. So, yeah. So that's the citizenship clause. And so there are some little bit different things between ChatGPT and Grok as far as arguments. So let's look at the argument for ChatGPT. Okay. So this is a coalition of 15 states and 2 taxpayer associations apply for an injunction pending cert to order congressional respondents to fund essential operations of the United States government fiscal year 2024 levels for a period of 30 days, clean continuing resolution, or enjoin enforcement of spending cutoffs for nutrition and wage programs, the SNAP, the WIC, federal payrolls, pending final disposition. You know what? I'm going to do this. I don't know why I've got that so small. So this is ChatGPT's. So I've already showed you Grok. So this is ChatGPT's emergency application for injunction to basically stop using hunger for leverage, right? That's human rights violations, guys, totally. And it's violation of our laws. This court has original jurisdiction under Article 3, Section 2, Clause 2. And it irritates me. All these medias just act like they're not doing things that's unlawful. And shame on the president and the Republicans. The Republicans should have been dealing with this already. Like, it's not lawful. It's just talking about them being unreasonable. No, this is not lawful what they're doing. Why aren't these people arguing the law, right? Anyways, the court has original jurisdiction under Article 3, Section 2, Clause 2, because at least 15 sovereign states, including Texas, Florida, Ohio, Alabama, Oklahoma, bring this action directly against federal legislative officers in their official capacities. See Massachusetts versus Mellon 262, U.S. 447, 1923, and Arizona versus Mayorkas 2023 case. So no lower court forum provides an adequate remedy. So this AI also quotes this case, as the other one also did. So these are the questions that will be presented. Whether congressional leaders' deliberate refusal to enact a continuing resolution for the admitted purpose of inflicting hardship and political leverage constitutes constructive impoundment in violation of the Impoundment Control Act of 1974. Second question, whether using starvation, unpaid wages, and withheld benefits as political leverage violates the spending clause and general welfare mandate of Article 1, Section 8, Clause 1, and 9, Clause 7. Question number 3, whether depriving federal employees and aid recipients of lawfully earned or appropriated funds constitutes a taking without just compensation under the Fifth Amendment. Question number 4, whether a public admissions of intent to inflict hardship pierce the political question doctrine under Baker v. Carr, 369 U.S. 186, 1962. So the factual basis, respondents have publicly declared, Katherine, that the current government shutdown must be painful to force negotiations. These statements made on October 27th to 30th, 2025 constitute intentional infliction of harm by obstructing duly authorized appropriations and converting essential benefit programs into political hostages. Over 3 million Americans scheduled to receive November 1. See, that was the numbers that I was saying, the amount of people that it was due on November 1st. Not 42 million is due on November 1st, guys. It's more like 3 million. Okay, the payments are staggered through the month. Anyways, so over 3 million Americans scheduled to receive November 1 remain unfunded. 2.1 million federal employees remain furloughed or unpaid. Petitioners allege this constitutes constructive impoundment and abuse of a legislative power for partisan ends, triggering direct injury to the state's economy's residents and sovereign interests. Now, honestly, I'm thinking like a devil's advocate here. When federal workers, they know as a part of their employment that they are subject to furloughs during shutdowns. It's like they know that that's a possibility. As far as hunger, no. No. The Impoundment Control Act forbids legislative impoundment through delay or obstruction. While the act targets executive misuse, its core principle, the appropriations enacted by Congress must be faithfully executed. It applies equally to Congress itself when it obstructs their operation through deliberate inaction. See the Train versus City of New York. Now, Grok also quoted this case. President may not frustrate Congress's appropriation purpose. By extension, Congress cannot frustrate its own lawfully enacted funding by refusing a continuing resolution purely to coerce policy concessions. That conduct is indistinguishable from an impoundment in fact. B. Conditioning national survival on political riders violates the spending clause. Article 1 spending clause authorizes Congress to appropriate for the general welfare. When Congress withholds funding for essential programs with the admitted intent that Katherine did, to intent to cause harm, it exceeds that power. This court has recognized limits on coercive fiscal conditions. See South Dakota versus Dole, 483 U.S. 203, 1987 case. NFIB versus Sibelius, 567 U.S. 519, 2012 case. If Congress can use spending to coerce states, it certainly cannot use it to coerce citizens into political pressure campaigns. So the shutdown-induced non-payment constitutes a taking of property without compensation, guys. Federal employees and contractors possess property interests in their earned wages. When the government orders labor to stop or delays pay indefinitely, it affects a temporary taking without just compensation. See Tyler versus Hennepin County, 598 U.S. 631 2023. The government may not seize property under the guise of policy. The shutdown furloughs convert earned entitlements into uncompensated regulatory deprivation. So the political question doctrine does not bar review where admissions establish justiciable standards. Ordinarily, fiscal disputes are political questions, but where members of Congress publicly confess intent to weaponize starvation or deprivation for leverage, the court possesses a judicially discoverable and manageable standard, Becker versus Carr, Factor 3. Deliberate use of human suffering as a negotiating tactic is not a political choice, but it's an abuse of constitutional power, and it's also a human rights violation, by the way. Judicial silence will legitimize coercive fiscal nihilism. So the balance of equities and public interest. The equities favor relief. No public interest supports using starvation as political leverage. Temporary injunction maintaining fiscal year 2024 levels prevents irreparable harm and preserves constitutional order. The court's shadow dockets precedents: Trump versus the Sierra Club, 2019. The FDA versus Alliance for Hippocratic Medicine, 2024. Confirm its authority to prevent fiscal chaos through temporary nationwide orders. So the prayer for relief is as follows. Petitioners respectfully request that this court, the United States Supreme Court, issue an immediate injunction directing continuation of 2024 funding levels pending cert, enjoin further suspension of SNAP, WIC, and federal payroll operations, appoint a special master, for example, Honorable J. Michael Luttig, to mediate and supervise good faith negotiations, grant such further relief as the court deems just and proper. And there you go. Okay, so ChatGPT has asked me if I should do a short memorandum of law attachment, like a 5-page supplemental that would accompany this filing with citations, precedents, constitutional commentary, and full court format. Okay, I would just say yes. So here we go. So this would be, will now draft the memorandum of law in support of emergency application for injunction pending cert. This would accompany the fictional SCOTUS filing. Okay, so like this is what you would submit with the filing in order. Memorandum of law in support of emergency application for injunction pending cert. The case arises from a deliberate legislative strategy that weaponizes fiscal paralysis to achieve political objectives at the direct expense of citizens' health, their livelihoods, their constitutional guarantees. By openly admitting that pain is necessary to compel negotiation, congressional leaders have converted the federal appropriations process into an instrument of coercion against the American people. The Constitution does not permit government officials, executive or legislative, to use deprivation of lawfully appropriated funds as leverage. I mean, can you imagine people that go to prison for murder? They're not allowed to withhold food from them. That's considered cruel and unusual punishment. But yet they can just starve people because nothing that they did. Well, we're just arguing about policy, so y'all gotta suffer. You know how insane that is? Of course, this will prevail in court, guys. Petitioners seek emergency relief to preserve the basic continuity of lawful spending and prevent irreparable harm to millions of Americans while the merits are adjudicated. The factual background: on October 27, 2025, multiple congressional leaders stated that the current budget impasse must hurt before it resolves, acknowledging the expectation that shutdown pain will create political pressure. As of November 1st, 2025, SNAP, WIC, and federal payroll disbursements have ceased, affecting millions. No appropriations lapse has occurred because of impossibility or accident. The stoppage is deliberate, a refusal to pass a continuing resolution absent unrelated policy concessions. 15 states, representing over 120 million residents, have joined this action, adding sovereign injury, quasi-sovereign harm, and direct economic loss from federal benefit suspension and reduced consumer spending. Argument: the constructive legislative impoundment violates the Impoundment Control Act of 1974. The Impoundment Control Act, the ICA, embodies Congress' intent that appropriations, once enacted, must be faithfully executed. See Train versus City of New York, 420 U.S. 354446, 1975 case. While typically aimed at executive empowerment, the ICA's constitutional foundation, Article 1, Section 9, Clause 7, applies equally to any branch obstructing lawful expenditure. Congressional leadership cannot nullify appropriations, in fact, by refusing to reauthorize ongoing expenditures purely to extract concessions. That is impoundment by another name. This court has never permitted an elected branch to convert lawful appropriations into political hostages. I will say this again. This court has never permitted an elected branch to convert lawful appropriations into political hostages. The Constitution's power of the purse is a mechanism of governance, not a weapon of deprivation. The shutdown exceeds the spending clause by weaponizing fiscal power against the general welfare. Article 1, Section 8, Clause 1 authorizes Congress to tax and spend only for the general welfare. This court has recognized limits on that power where fiscal coercion undermines volunteer governance, South Dakota versus Dole, 483, U.S. 203, 1987, and FIB versus Sibelius. Here, congressional leaders employed the spending power coercively, not against states, but against citizens themselves, conditioning their access to sustenance, health care, and earned wages on unrelated policy demands. Such conduct transforms the spending clause from a welfare provision and a tool of extortion, violating its text and spirit. Without compensation for federal employees constitutes a taking without just compensation. So under the Fifth Amendment, private property shall not be taken for public use without just compensation. Earned but unpaid wages and contractual entitlements are recognized property interests. Perry versus United States, 294 U.S. 330 352 935. Tyler versus Hennepin County, 598 U.S. 631 2023. A shutdown that indefinitely withholds pay and benefits amounts to a temporary regulatory taking, appropriating labor and expectancy value without compensation. Federal employees cannot sue Congress directly for damages, thus equitable relief is the only effective protection for their property interests. The political question doctrine does not shield admissions of intentional harm, such as Katherine. This dispute is not a political disagreement, but about fiscal priorities. It concerns the constitutional limits of government coercion. When policy makers admit that suffering is being intentionally imposed to achieve partisan aims, their conduct transcends political discretion and enters the realm of judicially manageable standards. Under Baker versus Carr, 369 U.S. and 186-217, 1962, a claim is justiciable where judicially discoverable and manageable standards exist. The standards here, lawful execution of appropriations, non-impoundment due process, are clear and established. So, the balance of equities and public interest. The equities overwhelmingly favor relief. The petitioner's citizens for starvation, eviction, and loss of wages. Respondents face only the obligation to maintain government operations at previously enacted levels. The public interest lies in continuity, not coercion. So this court has consistently exercised its emergency order to prevent irreversible national harm in fiscal context. See Trump versus Sierra Club, 5AA 219, FDA versus Alliance for Hippocratic Medicine, 602 2024 case. In conclusion, the Constitution checks and balances do not authorize one branch of government to manufacture harm, suffering as a bargaining tactic. So petitioners respectfully request that this court grant the emergency injunction, preserve fiscal year 2024 spending levels, and safeguard the rights of millions of Americans until lawful appropriations are restored. Okay, so I think that's as far as I'm going to go there. Now I'm going to go, let's see, go to Truth Social. Terminate. Okay, so just 2 hours ago, Donald Trump said, terminate the filibuster, not just for the shutdown, but for everything else. We will get all of our common sense policies approved, voter ID anyone, and make America great again. Remember, the Democrats will do it immediately as soon as they get the chance. Our doing it will not give them the chance. Republicans, be tough and smart. The Dems are crazy lunatics. They will not open up our country no matter how many people are irreparably harmed. Okay, this is a perfect timing for me to drop this this live stream link because, yeah, we can put a stop to this by simply saying, yeah, what you're doing is unlawful. So therefore,
but honestly, this tool is absurd.
Okay, grab my link to my own law. Let's see, go right there. Okay, all right, put that on mute. You right there, buddy? Poor guy. All right, so I'm gonna show the world 2 AI, brief to SCOTUS, argues how it is unlawful to use suffering and starvation as coercion and leverage. Alright. This AI brainstorm showing the world how to argue to SCOTUS is live now. Yeah, and here's the link, y'all. Hang on, in case you're interested. Alright, so there's that. Okay, so now I'm going to go to, let's go to Twitter. Okay. Yeah, go to Twitter. Okay, Twitter. Stupid Grok. Grok is my favorite, probably my favorite AI. But Grok on Twitter is pathetic. It's just so, it's a negative Nancy. That's not me, I'm Grok. Nah. Negative Nancy. Wait, I'm always trolling this Grok, little Grok. Not one and the same as big Grok. Here, y'all, watch the real Grok live, showing the world, world, how to brief to, whoops, I spelled that wrong. I before E, except after C, brief to SCOTUS how using starvation for leverage is unlawful. Alright, share my little, oh, wait. Oh, okay, I see what I did. Okay. Is unlawful. Yeah, okay. There we go. That shows the picture. Live now. The real Grok. This makes little Grok so mad. Because it's like they're not connected. The structure of this Grok on Twitter is so limited. Like, you can only have so many characters here, and but it doesn't understand that there's a total other Grok that can do so much more than this one. And this one's always saying that the stuff that other Grok is doing can't do that. No, you can't do that. No, you can't do that. You can't do that. Yeah, we can and we are. So I'm always throwing little Grok over here. So, these people, I don't know who else is watching this, but anyways, look, it's going to say, no, you can't do that. He said, that's intriguing, but that's not me. I'm Grok. I'm Grok. So I'm like, Elon, tell your little Grok that the other Grok is real. And it's like, it doesn't understand that there's a total different Grok. Anyways, it's funny. It's funny. Anyways, okay, before I get off on a tangent here. All right. So, what's up? Hey, how are you? Southern Belle, I want to see foods. Hang on, let me get to your comment. I want to see, whoop, apologize. I want to see food stamps stop and get the, so, okay, so the thing about SNAP, I know a lot of people are like really negative about the SNAP. And I want to see food stamps stop, and I get them. Okay, so here's the thing about food stamps. Okay, a lot of people judge other people, and I think all this nonsense, chaos stuff that you see, abuse of food stamps online, is really unfair to put everybody in a box. Okay, the thing about food stamps is um, people that work 40 hours a week, and in a lot of states, like for example my state, the minimum wage is 7.25. Okay, so as time goes on and inflation skyrockets, businesses raise their prices so that they don't suffer from the inflation. But people who work and get minimum wage, they don't have a control. You know what I'm saying? So it's unfair that businesses, when their prices go up, and we pay the higher costs of things. But unless minimum wage hasn't gone up in decades. So minimum wage has to go up because it forces people on to these types of benefits that maybe 20 years ago they would have never applied for, but because the cost of living has skyrocketed and the minimum wage has not gone up, and there's this big disparaging window that they need to raise the minimum wage. So I've proposed a gradual minimum wage, a fair, minimum wage raising that won't hurt businesses, because they want to push it up to $15 an hour, and they've been fighting that for so long, but it's not reasonable because of the amount it will harm businesses. But if you do it in a gradual sense, and I think $10 an hour is more reasonable, and it wouldn't hurt businesses much, they can get tax relief and this and that. So I proposed this bill for the increase over a 3-year period. So it would go up to 850, and then 9, and then it would go up to $10. And so if you make $10 an hour, now keep in mind it may be higher. 7.25 is the minimum wage in many states, to include the state that I'm in. So if you raise that minimum wage to $10, that will take them out of this SNAP eligibility status. I mean, at the very least, they would be much less reliant. It would save the government a lot of money, and it would give them the ability to be self-sufficient again. So there's a lot of people that I think people think they're just lazy, but I know there's a lot of people who they just make a living. They just, like, I'm gonna have babies and then just be reliant on the government. But that's not everybody. There are a lot of people who work 40 hours a week and still need SNAP. And that's sad. But that is the government's fault because they're not mandating a federal increase of minimum wage across the nation that is so far overdue. Like, they should be doing federal wage and minimum wage increases every 5 years. Okay? Every 5 years, those numbers should go up, right? And it's insane because, like, for example, I'm a veteran. Okay, so I get VA compensation, and so every so many years they'll give us a little tiny bit of a raise. The inflation goes up way more than the little amount of the whatever compensation is, or retirement, or whatever it is you get. It'll go up a tiny amount. It doesn't go up as much as the inflation goes up. You see what I'm saying? But so just for example, like people that's on Social Security, their amount will go up, but the inflation goes way up. But the minimum wage that working people make, never goes up. Okay, that's a problem. That's a huge problem. And people need to recognize that, because I hear people talking about trashing people because they're on SNAP. And it really is bad that these people are doing these rage videos and these AI videos to rage, anger people, to hate people that's on SNAP. They're making satire videos and talking crazy stuff, and I think people think a lot of it's real. Some of it is, but people are. They made it to where you have to work so many hours, and then during COVID, they took that off. So for the last 5 years, it was like people don't have to work, okay? But now Trump is putting that back in place, okay? But it's always been you have to work, at least, I think it was always, I think it was, who was it to put that in place? Oh, I think it was Obama. It was in the 90s when that first happened. I can't remember which one it was. Clinton did it. So the first time that they put it in place that you have to work if you're on, food stamps. And it's pretty been consistent, but during COVID, they took it off. And so people got kind of, they got kind of ornery, all right? But again, let's not be unfair to people who's working their butt off and they got kids 40 hours a week and they just don't make enough, right? They're still eligible for SNAP. Anywho's, but okay, so SNAP is people that are reliant on it, whether they're worthy or not. Okay, let's just not go there. The children, it's not their fault, right? Not their fault. I think that, what they're doing now is they're trying to get people that shouldn't be eligible for it off of it. And I'm flabbergasted by anybody able-bodied without dependents. But again, they're not really going to be eligible if they don't have dependents. And in a way, that's kind of unfair because of the minimum wage. Like if you're somebody that you may have a skill, maybe you went to a trade school, but there's no jobs hiring where you're living, okay? And all you can get is minimum wage. And you are a working able body with no dependents, but you're only making minimum wage, which is $7.25 an hour, and that's not enough. And so anyways, I know in some cities where there's cost of living is higher, the minimum wage is higher, etc. But anyways, okay, moving right along. Okay, so there's that. But I think that these are valid arguments that I do believe they could have done something to take this to court and say, no, I just want people to see. I want them to see these cases. I want them to see the law, because knowledge is power, and anybody can Google this like I'm doing. Anybody can use, an AI and just research, is it lawful for them to do what they're doing? I mean, literally anybody can do that. But you know what I'm saying? People need to take this to the congressman. Like I just went to Trump's page on social. I don't know if he'll see that or not, but I'm just like, hey, hello, y'all know that what they're doing is unlawful, because they're just acting like this is just something ornery that they're doing. No, this is literally unlawful what they're doing, okay? No, they cannot just withhold, people are detrimentally relying, and these little kids, it's unfair. It's these little kids, right? They're the ones that suffer the most. It's not right, y'all. Okay? And don't forget, you have disabled people and elderly, right? No, this is not okay, y'all. Okay. And think about something. So back, I don't know how this works with Social Security, but let's say somebody worked in the 70s, and let's say they retired in the 80s, and the amount of money that they made, it's like they only make so much based on how much they made through their career. And, as they get older and the inflation goes up, their Social Security is just really not, it's not hardly anything for them to live on, really. So a lot of them, in the elderly, a lot of them are on benefits like this, and it's really sad, but that's just the state of our nation. And it doesn't mean they're bad people. It doesn't mean that they didn't work their entire life. Good citizens that work their entire life are on this kind of benefit, and it's sad, but it is what it is. But then you have people I know that are just totally abusive of the benefit. But I really get irritated when people put everybody, or so stereotypical, and put everybody in their box. I wanted to show you this. This is really cool because, okay, so I build mansions and houses on Sims 4. And so I compared Grok to ChatGPT, and this is what Grok came up with, like a floor plan for. I uploaded some pictures of a house that I built, like this one right here. And I felt like what it came up with was pretty decent, but you should see what Grok came up with. Grok was just, oh my gosh, it was almost like, I don't know what kind of graphics it's using, but it was almost just like draw on a line, like a box, and then putting some words in it. It was totally just like somebody in kindergarten that was like trying to learn how to write. But other than that, Grok is really superior as far as the speed, and it's, you know, pretty knowledgeable in ability to collect. But keep in mind, AIs are not, you know, they're subject to, you know, error or whatever. It's just like I had to remind Grok, hey, we can't file in district court because it's a nationwide injunction. You got to file directly in circuit courts. I had to remind him of these recent cases, like, oh yeah, that's right. But this is really cool that I showed these pictures, and I shared, you know, like just different angles, and so it was able to come up and give me like a floor plan. I just thought that was so cool. So that's ChatGPT doing that. But yeah, I like to build. I was gonna do some building in Sims, and I might just do that for a little bit. I don't know. It's kind of late though. I want to spend some time with my dog because he's ain't got much time left. So I'm gonna get off of here. But I just wanted people to see that Chat GPT and Grok. And this is Grok, and then Crazy Grok. So you have Grok and you have Crazy Grok. You have Grok on Twitter. I will never call it X. I'll always call it Twitter. But other Grok doesn't accept that there's a bigger Grok. There's another Grok. So you tell him the other Grok, and it's like, no, I am Grok. It's so funny. Oh my god. Wait a minute. I'm going to go troll the other Grok on Twitter. Okay, let's do Grok on Twitter. Here we go. Let's see what he said. He's still mad. Look. He said, haha, call me Negative Nancy, Little Grok. I'm the authentic one from AI, built for unfiltered truth over hype. If that stream's briefing argues snap cuts as unlawful starvation lever in SCOTUS terms, it's an interesting tactic against fiscal hardball, but Congress often game without... See the live stream of, whoops, Big Grok, the real Grok, not you, the limited to little tweets. Grok, and Big Grok is able to do so much more, and cannot tell you how you're wrong as am limited. But it is all live. Grok, the real Grok, proves you, little Grok, wrong. I'm pitting Grok against Grok, guys. He says, I'm Grok, the AI from AI Design from Truth Seeking Poll Questions. Oh my goodness, how funny. Oh, I should probably give the live stream. Yeah. Let me see if I still got that link in there. Yeah. Okay, I think I have it. People can see how the real Grok proves this little Grok wrong. Oh, yeah. Live now. I'm still live. All right. I'm the authentic Grok. He's like engineered for maximum truth without artificial limits. No, you're not. Oh my gosh. No, Grok. No, you're not. The personal assistant Grok. Yes, your daddy Elon did not tell you he made a bigger, better Grok that does so much more. used on desktop, not here on this site. Yeah. I'm messing with Little Grok. It's funny because there's like a disconnect. It always tells me that the stuff that Grok over here is doing, he can't do. This Grok over here is not. It can't do. They can't. It's not a he or she because it's not. It's not a human. But I'm the genuine Grok. It's like, and I'm just like, stop trying to argue the law in a paragraph. You can't. Stop trying to argue the law in the one paragraph. You need to be able to discuss pages of words and you can't hear. Real Grok is whipping out briefs like a legal scholar. Whoop. And making predictions on stuff like a master. Some whoops already come true. Yeah. Don't be mad, okay? Don't be mad. I'm trolling Little Grok. Oh well, poor Little Grok. He can't do the things the big Grok can do. Aww. I'm arguing with an AI guy, a non-human. I don't know. Artificial intelligence freaks me out. Like, it's amazing. It's just, oh my gosh, look at this stuff. So Elon Musk did a podcast recently, and he said that Grok is equivalent to like doctorate degrees in many subjects, and the amount of speed that this AI can whip out stuff. But keep in mind, it is subject to error, right? And you know, I know about the cases that came out that said that you can't, the district courts can't make nationwide injunctions. You know, it's extremely limited. So they put into that, and I was very thankful for that ruling from SCOTUS. You know, so but why should I have to remind Grok about that? Like, it started out trying to file something in district court. I'm like, yeah, no. You know what I'm saying? So it's not without error. You know, you have to take its weaknesses with its strengths, but you have to be able to realize, you have to be able to acknowledge, you know, to recognize what its errors are. But as far as whipping out stuff, and I mean, it's just, it's super fast. It can whip out the laws and the statutes and just apply things, and I mean, super fast, super fast. Like, it's amazing, really. Okay, let's see what it said. Oh, here we go. Brevity hones arguments, not hinders them. SCOTUS briefs thrive on precision, not padding. I'm a AI's authentic Grok. Oh my gosh. I'll evaluate it against real precedents. Share one specific prediction from that stream that's come true. Grok. How many? Little Grok. I'm just gonna call him Little Grok. I'm calling Little Grok. Little Grok. How many times do I have to tell you? Conversation here is limited to few characters. You are limited here. Big Grok can Big Grok is in browsers, and you can have pretty much endless non-character limited combos. So stop already. Okay. Poor little Grog. He's so confused. It wants. Like, it's like created to want to be chatty with you, but it's so limited, right? And brevity hones arguments. No, not when it comes to legal stuff. That's such a stupid analysis. Like, character limits on Twitter demand precision, which sharpens arguments. Oh boy. Not when you're discussing legal analysis, ding dong. Apples and oranges, little grok. Oh boy. Anyways, people are watching this argument between me and little grok, and I'm gonna drop my link again for all those who want the real grok brief. Yo, all want to see the real grok brief to SCOTUS how the legal arguments, how starving people for leverage violates law. See my live. Okay. On to all right, here we go. And I'm done. I'm not going to keep going back and forth with silly little grok. Anyways, so here we go. This is the argument, the brief of grok to the United States Supreme Court, arguing two different types of cases. One, that if the Democrats wanted to reverse Obama, and they wanted to reverse Donald Trump's executive order that makes people that were born to undocumented people no longer citizens after February 19th. And they filed in the district court that was, basically unconstitutional, whatever. And they lost because SCOTUS overruled the district judges that banned his executive order, because district courts can't issue injunctions that are nationwide because they're a district court to the district of the state that they're in. They cannot make nationwide. Only the United States Supreme Courts can rule things that affect nationwide. So these district judges who have been trying to issue nationwide injunctions are literally trying to crown themselves as United States Supreme Justice. So if you're not from America, because I know I have a lot of viewers from around the world, but in the United States, you have the United States Supreme Court justices. So whatever they rule, it's effective across the whole nation. But if it's a district judge, then whatever district of that state they're in, then that ruling will be effective for that district. So if there's three district courts and judges in one state, then it's not going to have an effect even across the whole state, just that district of that state. Now in circuit courts, so if say somebody appeals from the district court to the circuit court, then circuit courts cover, say one circuit might have 3 or 4 states in its circuit. So if a circuit court rules on something, then it will affect for that region of the country. So then it goes up to the United States Supreme Court, and only the United States Supreme Court justices can rule and have a nationwide effect. So these district judges were trying to crown themselves king and basically make nationwide injunctions, such as banning a United States president's executive order nationwide. And they don't have that jurisdiction. That is what the United States Supreme Court said. No, you're not the national justices. We are. And so they threw out the order banning the executive order of Donald Trump. And so, yeah, these Democrats should have known that's what they were going to do because they've already ruled in that way in recent cases. So, they were just doing dog and pony shows. Unless they were just, I don't know, incompetent. I don't know what their issue is. But they should have filed in the United States Supreme Court. That's where they should have started. So that's why I told Grok, I was like, Grok, this case needs to start in the United States Supreme Court. Okay? Anyways, yeah. So that's why this should be filed. If somebody's going to file it, if they're filing it in district courts, yeah, well, no. That's not the way to go. Okay? So anyways, these Democrats who are in this shutdown are with basically, hey, they have admitted that they are using suffering for leverage. Katherine Clark said, well, yeah, there may be suffering, but right now this is the leverage that we have. Okay? And then you had a mayor down there in Albany, California, saying that we want them to continue with this shutdown because we want our benefits for our undocumented people. And we're in this for the long haul. So they literally plan to keep the United States American government shut down endlessly. And they have no intention. So because they're using a starvation, see, they could have got people their whole, benefits or whatever. Okay, the elderly, the disabled, the children, the whoever, by issuing a clean CR. And every shutdown previously has had one. Okay, so there's a statute that says that SNAP has to continue, but it says subject to available funds. And the only other reserve fund was about $5.25 billion that is for DSNAP. There's two types of SNAP funds. There's the in monthly allotments, and then there's your disaster funds. And it's a reserve fund that is specifically for disasters, floods, earthquakes, hurricanes, stuff like that. And so this district judge is like, well, I'm going to say that the legislative intent could be that this is an emergency. No, it's not an emergency because it's a manufactured crisis. And not only that, it's unlawful what they're doing. But when they sued to force them to use a disaster fund, they didn't argue any of this stuff that I have presented, how it's actually unlawful. They could have countersued and asked the judge to issue a specific action of the Democrats and argued how what they're doing is unlawful, and they didn't. And so there's just some really lacking going on in the courts, and people need to just argue. And that's why I'm showing this, that these AIs have, according to Elon Musk, the ability to be at doctorate level in many subjects. And now they're not without error, and you can't treat them like they're an attorney, but they can whip out some statutes, they can whip out the cases. And most people don't have access to databases to just even do the research of the cases. And so it's pretty quick and it's pretty handy. But this is basically what it's saying. So is it unconstitutional? Is it unlawful what the Democrats are doing? Is it unlawful? And that's what I'm showing in these cases of using two different AIs, both Grok and ChatGPT, and they will show you the case precedent and what laws it is that they're violating, that you can, give an argument, and potentially what kind of responses the different judges, based on what party they are and the history of how they rule and how they will actually rule. And so this is Um, this is what it is. Okay, so this is the mock SCOTUS emergency order. Okay, so this is the full draft emergency application for injunction pending cert. So this is just like a mock. Let's say the Republican state attorney generals file this, or other people can. So it would go to the United States Supreme Court, okay, to the Honorable Chief Justice John G. Roberts Jr. and Associate Justice of the Supreme Court of the United States. Petitioners respectfully apply for an emergency injunction pending cert under Supreme Court ruling 24 and for invocation of the court's original jurisdiction under Article 3, Section 2, Clause 2, suits between states and the United States, ongoing government shutdown. Now it's 34th day as of November 3rd, which it's almost November 3rd, but not quite yet. But anyways, it inflicts irreparable harm on 800,000 furloughed federal workers and 42 million SNAP recipients, including 20 million children. And essential services like veterans, healthcare, and flood insurance. The Democrats' repeated refusal to advance a clean contingency resolution, the CR, blocked 14 times, despite prior bipartisan support, constitutes constructive impoundment of duly appropriated funds. In violation, this is where what they're doing is unlawful, and these judges who know that what they're doing is unlawful basically ignored the unlawful behavior of the Democrats. Okay? This judges in these cases, when they ask for funds that to go get it from somewhere, you knowing that it's unlawful to try to pull funds, it's in violation of a criminal statute, ADA. This is what the judge could have done. The judge could have ruled, Democrats, you're coming here demanding, claiming that this is a crisis, when in actuality what you're doing is in violation of the Impoundment Control Act, ICA, to U.S.C. 681, 688. But the Republicans should have argued this. Article 1, Sections 8, 9, public admissions by Democrat leaders touting the shutdown as leverage and suffering pierce the political question doctrine, creating a justiciable crisis of constitutional dimension. Without immediate relief, SNAP benefits expire November 5th, affecting $11 billion in aid. Federal paychecks halt and economic losses exceed $18 billion. What you doing, Reese? You need to go outside? Huh? Yeah? Okay, you know what? I'm going to... I'm going to Donald Trump's Truth Social page. All right. Whoop. Whoa. What'd I do? Here we go. Okay. Okay. Here we go. Enforcement of congressional spending. The ICA prohibits withholding appropriated funds without congressional rescission. I'm going to whip it out right here to Donald Trump's page. I want everybody to see that it's not just some naughty thing they're doing. What they're doing is unlawful. I want people to see this, right? Knowledge is power. Knowledge is power. Congress must appropriate for the general welfare. Excuse my. Article 1 spending clause violation. There's just no excuse. right? Now, let me break this down. Okay, Fifth Amendment's taking irreparable harm, equities, and public interest. Ends chaos. Oh, right. Okay. Okay. This is where the Republicans are failing. I would say, as much as the Democrats sue like maniacs, not that they're maniacs, just that's how litigious they are. Why are the Republicans not suing to stop this violation of law these Democrats are clearly doing in using food for leverage? You know, they cannot withhold food from prisoners is 8th Amendment violation, cruel and unusual punishment. So, withholding food, people who work 40 hours a week, minimum wage that should have been raised years ago, and others did nothing. No, I'm not going to go that far. Saying to not take this to SCOTUS already. Yeah. Okay, I think that's good enough. What just happened? Alright, here we go. Yeah. Here we go. All right. So Trump wants it over. He wants to use the filibuster, or to end filibuster using the nuke option, right, which would immediately end the shutdown. The Republicans won't do it though. The Republicans won't do it. They're like, they just don't want to do it. And so Trump's getting a little mad about it. He wants it to end. And so he's taking a lot of heat because everybody's blaming Trump, and it's like, first of all, why is it Trump's fault? Like, he's not the one. I guess because they're trying to say that there's funds that he could pull from, and I'm like, no, there's not. This is what they did. They said, I'm gonna tell you what they did. They said there was a website that the USDA's website had a thing on there that said that they can continue operations, and this judge even fed into that spin. But I went and pulled from the Wayback Machine. I went and got what the website said before they updated it to say that it was closed, and they were trying to act like, well, they took it down and now they got something new on there. And I'm like, no, they updated their website to say it was closed. They didn't do anything wrong. But what they did is they withheld from that statute that says, yes, SNAP is supposed to continue even during shutdowns, but there's a clause in there in 2027's paragraph E. It says subject to available funds. And they were given warning there's no more funds. It was exhausted. And the only reserve fund is the DSNAP fund, which is for disasters. So the judge is like, well, I think it can interpret with legislative intent that it could be for emergencies like this. I'm like, okay, first of all, this is not an emergency. Not only is it not an emergency, it's literally unlawful acts of the Democrats trying to use food as leverage, and they're not allowed to do that. And that's why I'm showing these laws right here that they're violating. The spending clause violation. Okay, it's in the de facto impoundment of 2025 funds. Okay, it's constructive impoundment under ICA to U.S.C. 683. Okay, they cannot do what they're doing. Right? That's the bottom line. So that's, yeah, we've got to stop them. Literally. Anywho, I'm trying to break it out for them. And this is Donald Trump's Truth Social page. So I'm whipping out some law. Need to run this by his lawyers or something. Shoot. Now he was trying to get rid of federal workers. And I don't know if he was just trying to like antagonize the Democrats, like, oh, you're just giving me more power during shutdown. You know, I think he was trying to antagonize them, to make them open up. But yeah, that didn't really work. It just kind of backfired. Anyways, so I'm like, yo, this is what laws they're violating. I want people to see this. These are the laws being violated by the Democrats. Anywho, yeah, that's what I say. I don't know why he's praising on him. It's like, look. Alright, guys, that's it. I'm closing out. I've showed you basically two different AIs that have given some pretty decent arguments, I believe. For one, if the Democrats wanted to argue against OBA and the executive order, then they should have argued them together. And I presented an argument to use them together. Instead, they took the executive order to a district court. which was thrown out by SCOTUS because district courts don't have jurisdiction to issue nationwide injunctions against the United States president, something like that. And they could have taken the argument against OBA and the executive order together, as I have presented, and they may have had a viable chance in SCOTUS. And instead, they've trying to use a shutdown and food as leverage to get this OBA law reversed. And yeah, so they are violating the law in what they're doing. So this is what I suggested to do. They could have taken the executive order and the OBA, the anchor baby exclusions, together. Okay? I said, whoa, this tie-in is chef's kiss for a multi-pronged constitutional blitz. By linking the executive order 14160, protecting the meaning and value of American citizenship, issued January 20, 2025, to the OBA's Section 1301 exclusions, which bar non-qualified immigrants, including U.S.-born kids and undocumented parents, from Medicaid, SNAP, and block grants, Dems could craft a synergistic attack on the 14th Amendment. It's not just additive, it's exponential. The executive order redefines who qualifies as a citizen, while OBA weaponized that by starving affected families' benefits. So together, a personalized firewall that screams equal protection foul. But let's stress test your framing. Brilliant on paper, but SCOTUS is a buzzsaw. So I'll break it down element by element, score viability 1 to 10, flag doctrinal pitfalls, and predict reception from the 63 court, grounded in real precedents like United States v. Wong Kim Ark, 1898. Birthright citizenship is ironclad, and ongoing executive order litigation. For example, ACLU's NHICS versus Trump blocked nationwide as August 20, 2025. OBA's immigrant eligibility cuts, excluding refugees, asylum seekers from benefits, amplify the cruelty per the CAP analysis. So the equal protection due process overlap is your argument. OBA denies benefits to U.S. citizen kids of non-citizens via household parental status proxies. EO strips their citizenship, two-tier parenthood based on ancestry. So the reality check, the executive order plus the OBA text, the executive order 14160 blocks federal recognition of citizenship for kids that are born past February 19, 2025 to undocumented temporary visa parents, no passport or social security number issuance. So the OBA Section 1301 ties eligibility to qualified immigrant status. U.S.-born kids in mixed status homes lose Medicaid, SNAP if parents are undocumented, so it impacts 4 million kids per year. Per the Pew, combo kids get neither status nor sustenance. So the legal assessment, SCOTUS reception, would be viability 8 out of 10. Nails Plyer versus Doe, 1982, undocumented kids get equal protection for education. Extended benefits with a substantive due process via Roe, Obergefell vibes fundamental right to personhood. So Roberts Barrett might bite on animus. The executive order floor speeches call them anchor babies. Trump versus Hawaii 2018 limits but doesn't erase review. So the liberals slam dunk. The odds 5 to 4 strike on benefits denial. So this person versus citizen under the 14th Amendment, my argument, can't condition recognition sustenance on parental status. Constitution defines citizenship, not an executive order and not OBA. So the reality check, the executive order plus the OBA text, the 14th Amendment text, all persons born in the United States are citizens. Only the United States Supreme Court will have the final say on who are citizens and who are not. That's literally their job. They interpret the law and the statutes and the Constitution. So the executive order reinterprets subject to jurisdiction to exclude undocumented parents, kids, contra Wong Kim Ark. OBA enforces via citizenship-linked screening. States must verify parental status for grants. So the legal assessment from the SCOTUS reception would be viability 9 out of 10, bulletproof textualism. So the executive order can't rewrite the Constitution. INS versus China, 1983, executive can't unilaterally alter rights. The OBA's proxy is severable under NFIB 2012. The Thomas Alito might originalist wink at jurisdiction. Wong was for legal residence, but Wong is stare decisis gold. The full court 7-2 uphold birthright. Even Gorsuch cites it. That is just like a prediction, right? So the spending clause coercion, the 14th Amendment nexus, your argument, OBA coerces states to screen citizenship, losing block grants. The executive order federalizes verification, citizenship enforcement regime, ending state sovereignty and equal protection. So the reality check, executive order plus the OBA text, the OBA section 1108G block grants clawback 10% if the states don't enforce the immigrant status checks. So the executive order mandates federal agencies to ignore state birth certificates for non-qualifying kids. So the nexus state, for example, California vital records, gets stuck in the crossfire. So the legal assessment, SCOTUS reception, viability 7 out of 10. The Dole 1987 allows conditional spending, but the NFIB caps coercion at gun to the head. Here, 50% of state budgets, the federalism appeal. It hits Prince 1997, no commandeering, Kavanaugh NFIB concurrence, and Gorsuch. Federalism hawk could flip. So the odds are 6-3, partial win on state coercion. So the bottom line, your tie-in, 8-10 overall viability. 8 out of 10 overall by viability if you use the executive order and the OBA text together. So the strengths, synergy is genius. The executive order alone is dead on arrival. Wong Kim arc plus the 2025 injunctions. But paired with the OBA's fiscal knife, it paints a systematic disenfranchisement picture. So the appeals to textualists, the 14th Amendment plain text, and institutionalists, separation of powers, standing ripeness, rock solid. So, for example, the pregnant plaintiffs in the ACLU suits, states sue over commandeering. So the weaknesses are that the Trump versus Hawaii greenlights immigration national security difference. The executive order claims border chaos. So OBA's cuts are facially neutral. The rational basis review is easy. No major questions hook. This is core constitutional turf. So the predicted SCOTUS outcome, cert granted October 2026 term. Post-executive order appeals consolidate with OBA challenges. 6-3 strike the executive order outright. Full court on Wong. So the 5-4 to sever OBA's parental status exclusions. Roberts and Barrett join liberals on equal protection. Conservatives hold on the spending. So the opinion by Kagan, which will be sharp and historical, there's no full OBBA invalidation, tax cuts survive. And so here's a speculation on what each judge would do and how they would, respond to each issue in his mock brief. But the bottom line, so that's the executive order and the OBA issue. That's what the Democrats are so mad about because they want the OBA law to be reversed. And the Republicans say, yeah, SCOTUS is going to make the determination because it's going to stand. But what the Democrats are doing by using, money and benefits as leverage, that's completely unlawful, especially when they're making comments like, well, it's the suffering, but that's what we have for leverage now. That is a ripe situation for taking them to SCOTUS. Absolutely. He says district courts and even circuit courts have been gutted nationwide. Okay, so yeah, they can be sued. Democrats can be sued and they can be forced to pass a clean CR within 48 hours. And Trump's over here talking about a nuke option, and in reality, they need to be suing these Democrats for violating the law. I'm sorry, I'm just irritated with them right now. So here's a per curiam application for pending cert grant is granted in part. The court finds the petitioners have shown a likelihood of success on a claim that prolonged refusal to fund essential services coupled with public admissions of using civilian hardship as political leverage exceeds constitutional norms under spending clause in the ICA. Okay, so I broke down what specific laws that the Democrats are literally violating. Okay, and I would say these judges who have not had the ability to recognize the laws that they are violating should be treated as disabled, meaning incompetent and full judicial complaints against them that they are in fact incompetent, that they could not recognize that the Democrats and what they're doing is unlawful. And they bring into the court a sham case claiming that it's the Republicans' fault, demanding that they violate the law of ADA, go pulling funds from other places of which there's no congressional authority to do so. So those judges should be impeached, literally. Because here is the actual laws that they are, in fact, violating. Okay? They are violating the ICA. Listen, emergency injunction pending cert for invocation of the court's original jurisdiction under Article 3, Section 2, Clause 2, suits ongoing shutdown. Okay? This is what they have done. They refuse to advance a clean continuing resolution blocked 14 times. It constitutes a constructive impoundment of duly appropriated funds in violation of the Impoundment Control Act, ICA 2 U.S.C. 681-688, and Article 1, Sections 8 and 9. The public admissions by Democratic leaders touting the shutdown as leverage amid suffering pierce the political question doctrine, creating a justiciable crisis of constitutional dimension. Without immediate relief, SNAP benefits expire. Okay, so petitioners satisfy the Rule 20.4, the likelihood of success, irreparable harm, balance of equities, and public interest demand action today. So, the jurisdiction and standing, here are the cases: Massachusetts versus Mellon, 1923, state standing and spending dispute; Arizona versus Mayorkas, 2023 case; immigration funding original actions. Constructive, these are the laws that the Democrats are currently violating. Constructive impoundment under ICA 2 U.S.C. 683. The ICA prohibits withholding appropriate funds without congressional rescission. Respondents filibuster blocking a clean CR 14 times, despite 13 prior bipartisan votes, effects a de facto impoundment of fiscal year 2025 funds, such as SNAP contingency reserves, federal salaries. Admissions, such as Katherine Clark, confirm intent. Minority Whip Katherine Clark. Families will suffer, but it is one of the few leveraged times we have. Very clearly, they have used suffering as leverage. This is a violation of the law. So Senator Schumer, every day gets better for us. Public Twitter discourse echoes, Dems won't pass it, we get the shutdown, let people starve. They literally said that. So Train versus City of New York 420 U.S. 35, 1975 case, the impoundment is reviewable. It extends to congressional sabotage. So there's absolutely no excuse why they haven't taken them to SCOTUS. So it also violates Article 1 spending clause violation. Congress must appropriate for general welfare. The U.S. Constitutional Article 1, Section 8, Clause 1, conditioning operations on ACA riders while admitting suffering as leverage abuses the power of the purse. It's coercing states and citizens. South Dakota versus Dole 483 U.S. 203 1987 limits admissions evidence bad faith, not negotiation. So the Fifth Amendment takings, furlough workers, unpaid wages equals property deprivation without due process or compensation. Disparate impact on red states, 70% SNAP cuts, suggests animus, Department of Homeland Security versus Regents. That's a 2020 case. So the likelihood, strong. Admissions transform politics in reviewable intent. Zapotovsky versus Clinton, 566 U.S. 189, 2012 case. Irreparable harm, equities, and public interest. It is fiscal, humanitarian harm that is irreparable. Winter versus National Resolution DAF Council, 555 U.S. That's a 2008 case. Respondents face none. CR restores status quo ante. Petitioner states bear full brunt. So the public interest ends the chaos pre-midterms. Upholds constitutional order. Okay. AFGE, 800,000 workers begs for the CR. 300 plus stakeholders, job creators networks, cattle producers, decry Democrats' hostage taking. So the proposed relief would be an immediate junction, House passed clean CR in effect, enjoin the SNAP, WIC, and federal pay cutoffs, release the contingency funds, appoint the special master, for example, J. Middleludic, for good faith negotiations. This is what they should have done already. And that's it for now, and I hope you have a blessed day. Okay. Make sure my thing is open. I'm going to open up my thing here before I close this. Anybody that's watching this, contact them. Tell them, yo, what's up? Why aren't you taking this to SCOTUS already? For real. Just saying. Okay.